Hello and welcome to Restoring Our American Republic. I'm Chuck Benoit with the Nature of Things, where we are realigning God, government, and natural law so that we might restore our American Republic. I'd like to discuss the bill of the Bill of Rights Sanctuary Ordinance, which will hopefully be addressed by the Lake County commissioners soon. The Bill of Rights Sanctuary Ordinance is designed to empower elected officials to honor their oath of office, the oath of protecting and defending the Constitution. It's also designed to prevent unconstitutional government overreach by officials and their agents, and guard against future emergency abuses similar to those seen in 2020 with COVID. It's designed to establish clear local jurisdiction and enforcement mechanisms. That's important, actually having enforcement mechanisms, and provide judiciary clarity and due process. It also equips the sheriff with lawful authority to enforce constitutional protections through local legislation. Now, you may think that our commissioners wouldn't have a problem with that, but that is not necessarily the case. If you pay attention to politics at almost any level, you know that the U.S. Constitution is trampled on regularly. And what this ordinance does is gives our local sheriff the means to prevent this from happening right here in Lake County, Florida. So my encouragement to all is to email, write, or call every Lake County commissioner and ask them to support this ordinance when it is taken up here in our county soon. For the emails of our county commissioners, you can go to lakecountyfl.gov/board-of-county-commissioners, or just look it up on Google. So with that, good morning, Mr. Levine.
Good morning, Chuck. Isn't it fun to immerse yourself into the complexities of government?
Yeah, right.
Pretty interesting. And I'll tell you something, Chuck, as we take a look at this Constitutional Sheriffs and Peace Officers Association ordinance that a lot of the some of the law enforcement communities pushing around the country. And of course, our good friend and enthusiastic advocate, Rick Carlins, has been pushing it here for over a year. And Rick Carlins has gotten so many great things actually done through the Board of County Commissioners. So we have to give a hat tip to our friend, Rick Carlins. He's amazing. And he does get this done. And I believe he will get this done. But when you take a look at the no vote, who would vote no for this? And a commissioner under the advisement of legal counsel might say that this is just going to increase the civil expenses associated with enforcing something like this. That's probably the argument against. So I just want to audience, while I am 100% in favor of it, I'm told that our Sheriff Peyton Grinnell is 100% in favor of it. And I'm told that our chairman of the Board of County Commissioners, Leslie Campione, has agreed to put it on the agenda at some point. There is a counter argument, and that's the establishment always telling you not what you can do to be proactive and create good things in our society, but they tell us about the dangers and liabilities associated with the things that we want to do, which often puts a wet blanket on our initiatives and our efforts, Chuck.
Yeah, it's always scarier to stand up for your rights than let them just abuse them.
Be trampled on. Exactly.
Yeah, right.
Yes, exactly. Very good point.
There you go.
All right. Thanks for that.
Sure. So this morning we're going to take a look at SB 840, and this is we're going to kind of see how it affects HB 1465, which we talked about Tuesday, and SB 180 that was actually passed into law last year. This particular bit of legislation was put up on the agenda by Senators Nick DeCiglia, Debbie Mayfield, Don Gates, and it's called Restrictions on Local Government After a Hurricane. What this does is it changes the municipalities and counties affected by this part of the law to those within 50 miles of the track of the storm, as opposed to in the past it was 100 miles. So it's a little more restrictive as to who this impacts. The provision of
That's
this
correct.
bill applies when hurricanes are listed in a federal major disaster declaration pursuant to the Robert T. Stafford Disaster Relief and Emergency Assistance Act. Is there anything about that Robert T. Stafford Disaster Act that we should know about? Just pretty standard what we've been working with.
It's just it's federal. So
Yeah.
basically, in order to stay in compliance with federal disaster relief initiatives, um, that's how they reference it. And that way they don't have to describe it in the bill. They just reference to that and that's it. So it's a federal program. That's all we need to know
Okay.
about that.
Under this bill, for a period of 1 year, there are a few things that governments, local governments, may not do. And the first one is they may not enforce a moratorium that prevents or delays the repair or reconstruction of an existing improvement damaged by such hurricane unless the moratorium is imposed for the purposes of addressing stormwater or floodwater management, potable water supply, or necessary repairs to or replacement of sanitary sewer systems.
So,
Sounds
basically, if you have a comprehensive plan amendment or a land use regulation amendment that's been approved by the county, and then you get a storm coming through, and the county says, you know what, since we approved that amendment, we don't like that anymore, so we're not going to enforce it. And this is very similar to what we talked about in 1465. Okay, it says, and if you're a property owner, you don't want your rights diminished by a change in the comprehensive land use plan or land use development plans, or again the bill goes on with the various different things, land use development orders, etc. So I think it's reasonable, although you shouldn't have to ask for it, right? I mean, local government should be respectful of property owners' rights, and you shouldn't have to get the state of Florida to force you not to change the game, not to change the rules in the middle of the game. But obviously, and again, you can just take a look and see, what happens locally with these various different land development plans. And everybody's not on the same page, right? And this is what you hear from the state of Florida, state legislators, et cetera, when they come out and they start smacking these counties and cities with these um, mandates. It's because they say, well, look, people are putting reasonable development requests in front of these local governments, and the local governments are rejecting them. I mean, we just had a very, I would say, I don't want to say contentious, but obviously a 1,450 unit residential development up in the Lady Lake area just passed through our local Board of County Commissioners in Lake County 3-2. And, of course, our Commissioner Sabatini from District 1 was very outspoken against that particular development. And Kirby Smith from District 3, the Tavares area, voted no. But Tim Morris from District 5, where the development actually is going, voted yes with Commissioner Campione and Commissioner Parks. So there's the property, that particular development was reduced from 1,600 units to 1,450 units. And they put some provisions there that said the infrastructure would go in advance of the construction, which persuaded the 3 yes votes to agree to it, which they probably would have agreed to it anyway. Without the opposition, they probably would have never made those corrections. But so you can see how contentious this is. And, the state of Florida wants the development. And that's what you're seeing in House Bill 1465. It said that you can make all the comprehensive plan adjustments you want as long as you increase density and intensity, right? But in 1465, we said Tuesday that if you want to reduce density or intensity, then we're going to prohibit you from doing that. And we're also going to empower those landowners and developers who want to develop high density or medium density projects in your district. We're going to empower them to sue you in court. And we're going to also give them recourse in this legislation, which means if you go to court, local government, you're going to lose and it's going to cost you a lot of money. So you need to rubber stamp these development plans, Chuck.
There we go. Another thing, this legislation says local governments may not require the repair or reconstruction of an existing improvement damaged by such hurricane to comply with amendment to its comprehensive plans or land development regulations, which was first effective after such hurricane made landfall in this state. Boy, that's a confusing statement.
Yeah, basically, they're saying that if you amend your comprehensive plan or your land use development ordinances after a storm, then you can't force that upon upon property owners who have applications in before the storm, which sounds reasonable to me.
There you go. And then a third thing this legislation may not do is enforce a change to procedure concerning review, approval, or issuance of a site plan, development permit, or development order to the extent that those items are defined in statute 163.3164, which increases the time frame for the impacted local government to take final action on such review, approval, or issuance, and which is effective after such hurricane makes landfall in this state. Do you mind trying to explain that?
Sure. Just like we said on Tuesday, justice delayed is justice denied. And if we don't like, if we have concluded that there's something about your application that we don't like, then if we can't get it done through the approval process, we'll just drag it out and make it very expensive for you to do this. And eventually you'll be discouraged and maybe you'll go away. That's what that says. And this law is preventing local governments from um, uh, changing the process of these land development proposals, applications, to drag out the process and make it more, a slow, laborious process, because time is money, Chuck. And that's just the way it is. Keep in mind, Chuck, not only that, but markets change. So I've seen in my career robust markets in 2005 just fall off a cliff when you're doing like lots of building permits every month, and then all of a sudden the building permits just dry up. So because the market has changed for one reason or another, and so that's another piece of it. As the longer these development plan applications are delayed, that creates risk of a change in the market. So you can't sell the product that you're building, Chuck. And that's a major concern for developers.
There we go. Well, also SB 840, just reminding everyone out there what we're talking about, defines circumstances under which comprehensive plan amendments, landfill development regulation amendments, site plan development permits, or development order approved or adopted by local governments may be enforced. So I've got 4 points here underneath this. They may be enforced when the property is owned by a private party, the applicant is not a local government, and the applicant is the owner of the property. Also,
Right. So that goes into, okay. I mean, I'm just going to this is a complexity that I don't know is so important that we get to the bottom of. But a lot of times, developers will put property under contract on a with a lease option or something like that, and it's contingent upon the developer getting the land use entitlements on behalf of the owner before closing. So that kind of goes into the idea, who actually is the applicant here? Is it the property owner, or is it a developer who's seeking to change the entitlement in order to change the use of the property so that their development plan is feasible. So that's I think all we need to say about that. Some people are going to understand what I just said, and some people aren't. And I guess we just have to live with that today.
Sure. And another thing may be enforced is when the proposed comprehensive plan, etc., amendment is approved by the state land planning agency for an area of critical state concern.
Right. So we see that a lot in Lake County because we have the Green Swamp, which runs all the way down from south of Polk City and Auburndale all the way up to uh, Mascot, let's just say. So it's a long run of an area of critical concern, which is it's a water basin there, and that's land that's critically protected by the state of Florida, and they don't want any development in there because it messes with the water table. So that's what they're saying, that your change the comp plan or your land use regulations or whatever can be enforced if it has to do with areas of critical concern, Chuck.
Okay, well, the next thing it may be enforced when when the adoption of the comprehensive plan amendment is required to comply with state or federal law.
And of course, like we said on Tuesday about 1465, the state wants its laws complied with. So it's going to statutorily allow local governments to change comp plans and land use regulation plans in order to be compliant with the law. Makes perfect sense.
Sure. So then finally, when the adoption of the comprehensive plan amendment implements a floodplain management standard consistent with 44 CFR Part 60. What's that all about?
Yeah. 44 CFR Part 60 are the regulations that determine whether a jurisdiction is compliant with the federal flood insurance program, Chuck. So that depends if you can get flood insurance on your property or not, right?
There you go.
So that's another reference to a federal program because Florida wants to make sure that that we get the benefits of federal money when we are due. And that means that those development plans have to be consistent with federal relief programs.
Yeah, absolutely. Makes all the sense in the world. Okay, the next point on our list here is the prohibitions cited in paragraph 2B and C only apply to property damage such as an extent that a permit is required for the repair or reconstruction of the existing improvement. In other words, sometimes the damage doesn't need a permit. Are they just making
Yeah,
that
that's
distinction?
exactly what we're saying. So this is kind of low hanging fruit. You almost should, again, there's so many times um, legislatively, you have to say things and codify it into law that you think would be common sense. But if it's not codified into law, then a judge isn't going to enforce it. So here they go. And they're saying um, that this legislation does not cover repair replacements that do not require a permit. The owner can do what they want. That's basically what this is saying, which you would think that's obvious, but it may not be in some cases, Chuck.
Sure. And then our next point is an impacted local government may require a property owner to provide documentation demonstrating that the property was damaged by the hurricane, including but not limited to documents produced by property appraisers, insurers, or local building inspectors.
Right. And here's another situation. This is the Senate being gracious to local government and says, if for any reason, and if you look at it at face value, you would say, well, if a government agency doesn't believe that this is a legitimate um, cause for the application, then they could require documentation, which you would think, if you're on the other side of that, you're going to say they're just obstructing. But they do give the local governments the ability to require the property owner who's applying for the permits for those development plans and stuff to prove that his property was in fact impacted by the storm. And while it can be cumbersome to do that, a lot of government would say that's not unreasonable. Because keep in mind, the permitting process itself is pretty cumbersome, Chuck.
So then SB 840 strikes provisions that allow entities to sue local governments or provide injunctive relief to enforce the prohibitions above. Well, that's a good thing as far as I'm concerned, right?
Yeah. Oh, yeah. That's the big deal. I mean, honestly, and when, as we're evaluating these bills, it's very easy to ignore the strike throughs, but the strike throughs are often the most important part of the bill. And I would say that the strike throughs in this particular case are extraordinarily important because this is what protects local governments from a barrage of lawsuits with every person who's putting in a comprehensive plan amendment application or land use regulation amendment application. That just gives them the power to sue and, of course, recover, costs and attorney's fees and all that kind of stuff. So, and keep in mind that 1465, the House bill, does not do this. The House bill wants these local governments on the hook for that. And as a taxpayer, I don't want my county commission and my city council being dragged through expensive litigation over land use change amendment applications that the city council and the county commission oppose. I don't want that. I want people to negotiate these things out and collaborate and find common ground. I don't want to go to court and spend millions of dollars on lawyers to determine that we're not going to do something, Chuck. That is just that's the epitome of bureaucratic entanglement.
There we go. SB 840 also strikes provisions that suspend local government's enforcement of comprehensive plan amendments until courts determine whether or not the local government has the right to enforce the amendment under, I guess, it's statute 252.422.
Right. So basically, if a landowner comes in and threatens to sue the county or sues the county, then under the SB 180, they would be entitled to injunctive relief immediately, and the comprehensive land use amendment would be suspended until the issue was resolved. So that would open the door technically for other people to run in under the wire because the land use amendment is suspended and possibly submit more applications under the same guidelines as the existing applicant who's suing the county. So again, this is just blocking and tackling depending on which side of the argument you're on. But if you're a landowner or developer, you're saying, yeah, great, I'll sue them. That'll automatically result in injunctive relief that suspends the effectiveness of the land use amendment. And that's bad for the county. And the county will become much more reasonable of their consideration. See, this is what everybody needs to understand. The legislation, it'd be great to live in a black and white world where either you either follow the law or break the law. But no, that's not the way it is, especially in land use and these kinds of issues, because all of this stuff becomes negotiable. And people will submit a development plan, and the county commissioners or the city council will say, well, we're not, we don't like this plan, and we don't like it because of these three things. And then the developer comes back and says, okay, great. If it's those three things that you're interested in, then let me adjust my plan to accommodate your concerns. And then it goes back and forth. And most of this stuff is done outside of commission meetings and city council meetings. This is done with the planning departments and zoning departments and stuff like that. And then it comes into the city council meeting or the county commission meeting as a recommendation from staff, either to approve or not approve. And then the commissioners and the city councilmen, they've been talking with these developers in theory, in some cases, for months and even years before this even comes before the local government body. So, it'd be so much simpler for us, everyday people who aren't necessarily engaged in these types of activities to live in a black and white world. But unfortunately, we don't live in a black and white world. And even legislation that's codified into law is challengeable and debatable. And the intent of the law, this is why God made lawyers, right? To determine what is the intent of the law, what is the application of the law, or, does my situation um, fall outside of some of the protections of the law or some of the demands of the law, stuff like that. So it's not black and white all the time, Chuck. And I suggest I'm in favor of this particular provision because again, um, I don't want to see our local governments tied up by, and keep in mind, there's millions and millions of dollars of profit in these developments. So these guys have a lot of money to work with, typically, and they have a lot of time and money. Well, not time because time is of the essence, but they have the resources to hamstring government. And then, of course, just like government is like any other person, right? When you get strung out on these deals and you're paying legal fees month after month, year after year, eventually you get, and taxpayers get burnt out on it. So yeah, I'm in favor of this provision because it prohibits developers and landowners from getting injunctive relief from courts that suspend the implementation of a comprehensive land amendment or a land use regulation amendment, Chuck.
Okay. One of our final comments is that HB 840 clarifies that uh, local adoption of building code regulations and local technical amendments under statute 553.74, I guess maybe paragraph 4, cannot be construed as violations of statute 252.422, this section of the
Right.
law. Wow.
So this is just the Senate, the sponsors of this bill, um, kind of circumventing some of the back and forth that I just referred to. So an applicant might drag in, changes to building codes, changes to, whatever the issue is in order to complicate the matter so that, you know, to potentially cause all of the litigation that I just referred to. So the Senate just took the opportunity to clear that up in this particular provision of the law, Chuck.
So our final note here is that SB 840 has survived two committee stops, Community Affairs and Judiciary, and both of these committees passed unanimously, passed 840 unanimously. And the next and final committee stop is the Rules Committee. Where do we go from here, Mike?
So I would just say that this is going to pass through the Senate. The Senate is going to approve this bill. And from then, of course, then 1465 or some committee replacement on the House side would have to be um, agreed so that the bills in the House and the Senate match. And when the bills in the House and the Senate match, then it'll go to the floor for a vote, provided it clears the House, of course. And it's also 1465 is on track to clear the House. So, and keep in mind, all of the things that we prefer in Bill 840 on the Senate side could be negotiated out between the House and the Senate before this bill goes to the floor. So we're not out of the woods on this. I mean, if you're a city, if you believe that your cities and counties should be protected from these laws coming out of Tallahassee, like SB 840, what we're talking about today, does a better job of protecting local government than 1465 does, then you would prefer the Senate version of the bill to be adopted, not the House version. So that's kind of where we are. But we don't know that until we go through the reconciliation process and the terms of this legislation are agreed between the House and the Senate so that it can actually go to the floor on both sides for a vote, right? Is that clear, Chuck? Did I make that clear or did I muddy up the water with that?
I think I'm a little clearer on it. Yeah, hopefully our audience is. Yeah, the reality is that being a part of the governing process is confusing. And in my estimation, the more people out here like yourself who's willing to at least help us understand these things, like the better. I just feel like this is a value, but it's hard, I think, to get the average electorate out there interested enough to actually do something about it. I mean, we can call our legislators, we can call our state senators and make our thoughts known. And you can't do that if you're just stuck in the legal interpretations. You know, I read this stuff and I get very confused. And you know, someone like yourself helps clear up the confusion. So all our people out there, please like and share this, and try very hard to stay as involved as you can possibly stay as our state government continues to, in many ways, attack the local government. So we are pretty much out of time. So Mike, why don't you just give us a final wrap up?
Yeah, here's my comment, Chuck. I would like to see our local government officials much more involved and proactively involved in defending themselves from these laws that are coming down from the state of Florida. And you see it that these city councils and county commissioners sit silent as the state of Florida puts these mandates on them and these prohibitions and ties their hands behind their back over land use. And I'd like to see the city councils and county commissioners become much more proactive and leverage their political clout with voters and rally voters. And actually, I would, if I was a county commissioner, I would want to take a delegation of citizens from my district up to Tallahassee and lobby them on these specific bills, stating that, listen, this is bad for my county commission. This is bad for my city council. And this is a delegation of my constituents who agree with me that the legislation that you're passing in Tallahassee is not good for our cities and counties. And just, we need to go back to the old fashioned and keep the old fashioned methods of lobbying, which is citizen lobbying. And we need for our local elected officials to step up and start defending us on these issues. And and again, keeping in mind that local elected officials, and I would suggest constitutional officers as well, who have a lot of clout, really need to start demonstrating more leadership in these areas, because they're the ones that actually have the power to do things and not do things. And I do understand that there's risk associated with standing up to power, but that is what we elect these people for, not just to administer housekeeping activities in their various departments and boards, Chuck.
Well, thank you, Mike Levine, and thank you all again for tuning into our twice weekly live stream. Please follow us on Facebook at Restoring Our American Republic, or check us out on YouTube at Restoring Our American Republic ROAR. Please like and share the program, and remember, if you are unwilling to govern yourself, you will be governed by tyrants. Until next time, God bless you, God bless President Donald J. Trump, and God bless America.